Question 606. Oral agreements are A. Never valid, B. Also called parole agreements, C. Cannot amend written agreements, D. Both B and C. Correct answer is D. Both B and C. Oral agreements can be valid and legally binding, especially for certain types of contracts that are not required to be in writing under the statute of frauds. Parole agreement is indeed another term for an oral agreement, especially in legal contexts. The parole evidence rule deals with the admissibility of oral evidence in relation to written contracts. The parole evidence rule generally prevents the use of prior or simultaneous oral agreements to contradict, change, or add terms to a written contract that is meant to be the complete and final agreement. This rule aims to uphold the integrity and finality of written contracts by limiting the influence of external verbal understandings. While there are exceptions, oral agreements generally cannot amend the clear terms of a fully integrated written agreement. Therefore, oral agreements are also called parole agreements and generally cannot amend the terms of a complete written agreement. Question 607. For appraisal purposes, the replacement cost approach is likelier to be applied to new buildings because A. Newer buildings are constructed of stronger materials, B. The way depreciation is estimated, C. Older buildings have less value than newer buildings, D. Changes in zoning laws. Correct answer is B. The way depreciation is estimated. Replacement cost approach estimates the current cost of constructing a new replica of the subject property, using current materials, design, and construction standards. Depreciation, loss in value due to age, wear and tear, and obsolescence, is then subtracted to arrive at the property's value. For new buildings, estimating depreciation is more straightforward and often less subjective. There's less physical deterioration and functional obsolescence to account for compared to older properties. The appraiser can more accurately estimate the depreciation based on the building's age and expected lifespan. While material strength can influence depreciation over time, it's the estimation of depreciation itself that makes the replacement cost approach more suitable for new buildings. The method still accounts for the depreciation of those stronger materials. Older buildings have less value as a general observation, but it doesn't explain why the replacement cost approach is favored for new buildings. The approach itself aims to determine value, regardless of whether a building is old or new. Zoning changes can affect the value and potential use of a property, but they don't directly influence the applicability of the replacement cost approach. The approach focuses on the cost to rebuild, considering current standards. Therefore, the relative ease and accuracy of estimating depreciation for new buildings make the replacement cost approach a more reliable valuation method for them. Question 608. A listing broker knows the property he is trying to sell has some structural damage, inadequate insulation, and it is overpriced by 10%. Nevertheless, he runs an ad that reads, "Charming, well-constructed two-bedroom home for sale, not a fixer-upper. Great price." The rules governing real estate ads have A. Not been violated, the broker is merely puffing, B. Been violated, because the broker knows that the price is actually not great. C. Violated, because the ad lies about material defects, D. Not been violated, because everyone knows ads aren't true. Correct answer is C. Violated, because the ad lies about material defects. Structural damage and inadequate insulation are considered material defects that significantly affect the value and desirability of a property. The broker has a duty to be honest and not misrepresent these facts. The ad's claims of well-constructed and not a fixer-upper are direct lies that contradict the broker's knowledge of the property's condition. While great price can be considered subjective puffing in some contexts, when coupled with the misrepresentation of the property's condition, it becomes part of a misleading advertisement. The broker knows the price is inflated relative to the property's true state. Puffing refers to exaggerated or superlative statements that a reasonable person wouldn't take as a factual representation. Examples include, best view in the city, or charming neighborhood. However, lying about material defects crosses the line from puffing into illegal misrepresentation. Real estate advertising is governed by laws and regulations at the state and federal levels, e.g., truth in advertising laws, real estate licensing regulations, that prohibit false, misleading, or deceptive statements. Therefore, the broker's advertisement violates these rules by actively misrepresenting the condition of the property and potentially the fairness of its price given the undisclosed defects. Question 609. Older deeds and tax documents sometimes include the phrase, et ux, which means a. and wife, b. and others, c. individually, d. good luck. Correct answer is a. and wife. Et ux is a Latin abbreviation that stands for et uxor, which translates to and wife in English. It was commonly used in older legal documents, such as deeds and tax records, to indicate that a man was conveying or receiving property along with his wife. Prior to women being allowed to own property in their own right or possess equal rights to property owned by their husband, a deed or tax record often referred to property as being owned by the husband, et ux. Question 610. Prior to burning trash on one's property, the should be notified. A. Local air district, b. the Federal Housing Agency, FHA, c. the Police Department, d. the Real Estate Commissioner. Correct answer is a. Local air district. Burning trash can release pollutants into the air, and local air districts are the agencies responsible for regulating air quality. They often have rules and permitting requirements regarding open burning to protect public health and the environment. Therefore, to ensure compliance with local environmental regulations and obtain any necessary permits, the local air district should be notified prior to burning trash on one's property. This is especially relevant here in Grover Beach, California, where air quality is a significant concern along the coast. In California, the formal name for this agency is the Air Resources Board of the State Environmental Protection Agency. Question 611. To satisfy the statute of frauds, a listing agreement must a. be in writing and signed by the seller and broker, b. be in writing and signed by the seller, c. be notarized, d. does not have to be in writing, because it can be accomplished in less than a year. Correct answer is b. be in writing and signed by the seller. This legal principle requires certain types of contracts to be in writing to be enforceable. Agreements for the sale of real property and agreements authorizing an agent to sell real property, listing agreements, typically fall under this requirement. In California, as in many other states, a listing agreement authorizing a broker to sell real property for a commission must be in writing and signed by the party to be charged, the seller, in this case, to be enforceable. This is to prevent fraudulent claims for commissions. The statute of frauds primarily requires the signature of the party against whom enforcement is sought, the seller, who is promising to pay the commission. An unsigned agreement by the broker might still be enforceable against the seller if the seller signed it. Notarization adds a level of verification to a signature but is generally not required for a listing agreement to satisfy the statute of frauds. A simple signature by the seller is usually sufficient. Question 612. Which of these creates an agency relationship? A. Ratification, b. Estoppel, c. Express agreement, d. All of the above. Correct answer is d. All of the above. Agency by ratification occurs when a person acts on behalf of a principal without prior authority, and the principal subsequently approves or confirms that action. By ratifying the agent's conduct, the principal creates an agency relationship retroactively for that particular act. Agency by estoppel, or apparent authority, arises when a principal's actions lead a third party to reasonably believe that a particular person is their agent, and the third party deals with that person in reliance on that belief. Even if no formal agency agreement exists, the principal may be prevented, estopped, from denying the agency relationship. Express agreement is the most common way an agency relationship is created. It occurs when the principal and the agent explicitly state their intentions, either orally or in writing, that the agent will act on behalf of the principal. This clearly defines the scope of the agent's authority. Therefore, an agency relationship can be formed through a direct and clear agreement, through the principal's conduct leading others to believe in the agency, or through the principal's approval of unauthorized actions. Question 613. The longest period of time during which a farm can be leased is A. 10 years, B. 25 years, C. 51 years, D. There is no limit on lease term duration for farms. Correct answer is C. 51 years. The maximum lease on farm property is 51 years. For urban property, it is 99 years. This is outlined in California Civil Code Section 717. Question 614. The main goal of secured transaction laws is to A. To provide notice to future lenders, B. To ensure creditors take speedy possession of collateral, C. To regulate tax collection on real estate transactions, D. To educate debtors on their rights versus the lending industry. Correct answer is A. To provide notice to future lenders. Secured transaction laws aim to create a system for lenders to establish a priority claim to specific assets, collateral, of a borrower in case of default. The central mechanism for achieving this is perfection, which often involves filing a public notice, like a financing statement, that indicates the lender's security interest in the collateral. This public notice providing notice to future lenders can discover existing security interests in the borrower's assets. This allows them to assess the borrower's overall debt situation and the availability of unencumbered collateral before extending credit. This helps prevent a situation where multiple lenders unknowingly claim the same collateral. Question 615. In 1925, a subdivision had a restriction enacted prohibiting property purchasers from ever reselling the property to members of the Jewish faith. Presently, the restrictions: A. Enforceable, if a new purchaser agrees to follow it, B. Enforceable, if a majority of the current owners in the subdivision have agreed to follow it, C. Enforceable, but if an owner dies, the property can be left in a will to anyone, D. Unenforceable under any circumstances. Correct answer is D. Unenforceable under any circumstances. Such a restrictive covenant based on religious discrimination is unconstitutional and violates public policy. The Fair Housing Act, enacted in 1968, prohibits discrimination in the sale or rental of housing based on race, color, religion, sex, familial status, or national origin. While the restriction was enacted before this landmark legislation, it would still be unenforceable today for several reasons. 1. Fair Housing Act. This federal law explicitly prohibits discrimination based on religion in housing transactions. Any attempt to enforce such a restriction would be a direct violation of this act. 2. 14th Amendment. The Equal Protection Clause of the 14th Amendment to the U.S. Constitution prohibits discriminatory practices. While this primarily applies to state action, courts have often found discriminatory covenants to be against public policy and therefore unenforceable. 3. Public policy. Even before the Fair Housing Act, blatant religious discrimination in property ownership likely violated fundamental principles of equality and fairness in public policy. Therefore, regardless of agreement or support, the restriction against resale to Jewish individuals is currently unenforceable in the United States.